Hello everyone, this is Amir Said and you're listening to the second episode of the Viva Visa podcast by Adhami Law Group. In the first episode, Kousha Adhami, the founder of Adhami Law Group, talked about the differences between the visas, and then he talked about the SIJS program. In this episode, we will discuss about the eligibility of the applicants and who can apply or who cannot apply for these programs. We are going to learn about the tips that you may need to consider if you want to apply for this program. Thanks for listening and joining us. Now let's begin. Hi, Kousha. Welcome to the show.
Hi, Amir. How you doing, man? Thank you for having me.
Of course. Okay, Kousha. Let's begin with the first question. Last time you talked about the basics of the SIJS and what is it all about, and it was like the general overview about the whole process. Now we want to go further and go a little bit deep. Would you please let us know who can apply and who cannot apply for this program?
Yes, Amir, definitely. It's a bit complicated question because it depends at what stage you're in. I previously explained in my previous episode for our listeners the different stages required for a SIJS petition. However, I'm just going to again rephrase the requirement for a SIJS applicant. So, in order for a child to be eligible to apply for SIJS, number one, they must be under the age of 21 years. Number two, they must be physically present in the U.S. That's something that it's a must. The third factor is that the child must be unmarried. Fourth, the child must be placed under or in the custody of an individual within a state court or in a juvenile court. Fifth requirement is that the state court must make the findings that reunification with one or both parents is not viable due to abuse, neglect, and or abandonment under state law. And the last requirement in the state court process, on the first step, is that the court must make the findings that is not in the child's best interest to return to his country. Now, I'm going to give a couple of examples as to who does not qualify for SIJS. Okay, so number one, for example, would be a child who has reached the age of 21 years old. After the child reaches the age of 21, we cannot do anything else, because even if the state court grants this petition after the child reaches the age of 21, USCIS will not accept this process, because USCIS strictly requires the child to be under the age of 21. We've had cases where we obtained the predicate or the SIJS order from the state court before the child turned 21, I would say maybe even 20 days or 30 days. But we made sure that USCIS received the petition before she reaches the age of 21 years old. Because after the age of 21, SIJS is not considered and USCIS will deny the petition. Another example that a child who cannot obtain a state predicate order in the state court is if the child is actually residing with both parents in the United States or in California, because the requirement is that the child must be, or reunification with one or both parents is not viable. If the child is living with both parents, how the court can make the findings? So that's kind of self-explanatory. The third example that I would have to give is, this comes up a lot, is that the child or the petitioner must be unmarried. The definition of a child for the purposes of immigration is a person who is unmarried and under the age of 21. It sounds a little bit confusing because majority states define a minor as someone who is under the age of 18. But for the purposes of immigration, the child is defined as any person who is under the age of 21 years and is unmarried. So talking about the married aspect of the child or the minor, because obviously if you're over the age of 18, you can get married. And I'm not sure under what circumstances a child who is under the age of 18 years old would want to get married. But, I guess every state has its own emancipation laws. But I'm not going to go and talking about it. So if the child gets married at any stage before her green card is approved, the SIJS is revoked. The child must remain single and unmarried. We've had some complicated cases where throughout the stage before the green card was granted, after the state court process, during the second stage, which is the I-360 stage, the child got married, and USCIS automatically revoked the petition. So that's definitely a no-no. Another example would be that makes the child ineligible or the SIJS applicant for this particular petition is that if the child or the youth in this particular case receives some sort of a criminal conviction. Immigration and state law have different definition for criminal activity. So certain criminal convictions trigger inadmissibility and deportability for the purposes of immigration. That means the applicant or the SIJS applicant in this case could automatically lose its SIJS petition or application because of the criminal conviction that they've received. And we had few cases that this has happened, but it gets a little more complicated because if the crime has happened before the age of 18, then he or she is considered a minor for the purpose of that particular state, or like, for example, in California, and there are different regulations that govern criminal activities for minors who are under the age of 18. And then we have, criminal convictions that fall under felony, aggravated felony, misdemeanors. It's a wide area that, even sometimes I have to consult an attorney who specializes in criminal immigration. We call them as the pros or crim immigration attorneys. Okay. Another example or another category where the child does not qualify for SIJS is if they have some sort of a prior immigration violations. This could include some sort of a prior deportation order or immigration violations that also trigger inadmissibility and deportability. So when I say inadmissibility, that's a term of art. And same thing with deportability. Deportability doesn't necessarily mean that you get deported. It's what's defined under INA that makes the applicant ineligible for the particular relief or a program that they're applying for. And lastly, another example that can come to mind. Again, this list is not exhaustive. I mean, it could be so many other factors that can revoke or makes the SIJS applicant not be eligible for SIJS. But another example would be USCIS does not simply consent to the grant of SIJS. So, and it's really rare because USCIS can always exercise its discretion to grant, SIJS or not. again, it's rare circumstances when they don't consent to the grant, but they can, because USCIS always reserves that discretion to grant or deny the petition.
Perfect. Let's review. Would you please review the whole process and let us know what are the steps of a CJS case?
Definitely, Amir. Okay, so I usually categorize it in 3 different stages. Stage number 1 is the state court process. This is the process or the stage where takes place in the state court. We file the petition or represent the client in the state court to obtain the predicate order, the state predicate order that we later send to immigration. In that process, court must appoint an individual under the custody of the child, makes the findings for reunification not being viable due to abandonment, neglect, or abuse, and the court also has to make the finding that it is not in the child's best interest to return to his home country. That's stage number 1. The second stage is what I usually refer to as the USCIS stage. This is where we file the state predicate order with USCIS. And the predicate order must be filed usually, for the most part, with the child's birth certificate along with Form I-360. So this is the second step where the visa is actually filed with USCIS. Let me just reiterate. When I say visa, I don't necessarily refer to a visa like a tourist visa where you get to go outside and come back in. Okay, the visa is the I-360 petition. That's what USCIS has designated this petition to be called, the Special Immigrant Juvenile Status visa. Okay, but the second stage needs to be completed, the I-360, and then if the I-360 is not approved, the child cannot proceed with the third step, which is the green card stage. Okay. And this is when the green card is filed with USCIS. So first step is the state court. Second step is filing the I-360 with USCIS. And the third step is the green card. Okay. The green card stage or the adjustment of status application. So if I refer to it as AOS or green card stage, they have the same terminology, but I just want to not confuse our listeners and pretty much refer to it as a green card stage. Okay. Now, the green card stage, okay, can also be a bit complicated because even though USCIS initially or originally reserves jurisdiction to grant the green cards, the green card stage can also happen at immigration court if the child is in removal proceedings. So when I say removal proceedings, I'm referring to the immigration court, because if the child is in immigration court, 2 options are present. Either the immigration judge determines that the green card process can happen with USCIS, so the immigration judge terminates jurisdiction with EOIR or immigration court and sends the case back to USCIS, or the immigration judge reserves the jurisdiction and the green card or application of I-45 adjustment of status must be filed and granted by the immigration judge. So that's why I like to break this down. The I-360 is always filed with USCIS. USCIS has ultimate jurisdiction of it. But the green card, depending on where the child is, because in a lot of our cases, we have unaccompanied minors who entered the U.S. And are initially placed in immigration court. So it can even make the process even more overwhelming and complicated, because when a client comes to our office with their relative or parents who want to do SIJS, I usually tell them, listen, we're going to be at 3 different places at the beginning. We're going to be in state court, USCIS, and immigration court. So we have to pretty much knock them one by one, and at the end stick to either USCIS or immigration court for green card.
Okay, so we have 3 steps for a CJS case. The first one is the state court, as you mentioned. What causes denial in the state court?
Okay, Amir. It's a bit, again, complicated question because it's very fact-driven. But I'm going to give examples of what we have encountered or what I've seen throughout my practice. Okay, so a couple of examples of causes a CJS petition that is denied in the state court would be, for example, if the petition is improperly filed and the child ages out. So, as I mentioned previously, USCIS must receive the predicate order before the child reaches the age of 21. So this means that the predicate orders must have been issued before the child reaches the age of 21, so USCIS can receive it. So the second, let me see how I can put this. The second causes that I've seen, or mistakes I've seen even with attorneys, is that they filed the petition in the wrong court. You must ask yourself, what do you mean by that? Okay, so it's a matter of jurisdiction, and it's a matter of where the petition can be filed. If the child is under the age of 18 years old, and residing with one parent, the state court process or the CJS petition must be filed in a family law court. Okay? So if the child is residing with one parent
And must be 18 years old.
and under 18 years old,
Not 21.
yes, because California law defines a minor who is 18 years old. And since we're doing a custody, so family law court reserves jurisdiction for a minor who is under the age of 18 and one parent is present. So, for example, if we have a mom, okay, who is like, for example, 30 years old, and the child is 15 years old, and in this case, the child was abandoned and neglected by his or her father in her home country or in the US, doesn't really matter. The petition must be filed in a family law court. Now, there are different factors that determines that the petition is to be filed in a guardianship court, which is a subsection of a probate court. So, if the child is residing with one parent, okay, the child is residing with one parent, and the child is over the age of 18, and the parent, mom or dad, are filing the petition must be filed in a probate or a guardianship court. Because family law does not have jurisdiction for the minor who has reached the age of 18. And there are 2 other examples where the petition gets filed in a guardianship court. First example is that both parents do not reside in the US, so we're making the reunification not viable with both parents, and a family member is filing the petition. Like for example from an uncle for a niece or a nephew, must be filed in a guardianship court. And the last example or scenario would be if a non-relative, like for example a friend or an employer or whatever, is filing the petition for the minor. So if it's a non-relative, the jurisdiction lies with the guardianship court or the probate court. Okay.
In the first episode, you mentioned that the applicant must be under 21 and unmarried. But now you said that the applicant must be under 18 years old. What is it? What do you mean by that? I'm a little bit confused.
My short response is to tell you that welcome to the story of my life. Trying to explain this. Okay, so immigration defines a child as an unmarried person under the age of 21 years old. Okay, but state courts still reserve the jurisdiction to have their own definition of a child. However, regardless of the circumstances, so long as the predicate order is issued before the child has reached the age of 18 and sent to USCIS, we're okay. Okay. For family law courts do not entertain or grant petitions for SIJS or custody orders if the child has reached the age of 18 years or older. That's why California Assembly has passed a law. I don't recall exactly when it was. I believe it's in 2015 or 2016 to extend the age of guardianship in correlation with a SIJS petition to 21 years of age. Okay, so for example, if Maria, mom, is here with her daughter, and her daughter is 19 years old, and she's been abandoned and neglected by her father, the petition must take place in a guardianship court, and the guardianship court will grant the petition. I mean, of course, it must meet all the requirements, but the guardianship court will grant the petition even though the child is over the age of 18 in correlation with the SIJS finding. So the guardianship court will appoint the mom as a guardian and will make the SIJS findings regarding reunification and factors that are not in the best interest of the child, which takes me to the next step. And to a situation that I encounter a lot from clients and other attorneys who do not specialize in SIJS. So we get calls to our office where the child is 20 years old and is, for example, turning 21 in few months, like 4 months, 5 months. Okay. In this case, what we usually do is that once we screen the client to determine that they qualify for SIJS and they have a petitioner, like for example, a mom or a family member, the petition must be filed immediately. Okay? And the hearing date must take place before the child reaches the age of 21 years of age. Okay? So, for example, in one of our cases, we had a client who came to our office, and she was 20 years and I believe like 9 or 10 months. And her previous attorney completely screwed up her case. He didn't do SIJS. He waited last minute, and then client found out about SIJS, and she was furious. She was angry. Mom was upset. Daughter was upset because they spent a lot of money with that previous immigration attorney who didn't do a good job and did not file the SIJS for them. So when they hired us, what we did was we filed the SIJS petition immediately, and we got a hearing for I believe she turned 20. She was turning 21 on I believe like September 5th, but we got a hearing for December. So what we had to do was to file an ex parte application. And ex parte is just fancy word to ask the court to exercise its discretion based on the exigent circumstances that we have, because she was turning 21, to advance the hearing to an early date. So once the judge advanced the hearing to an early date, which I believe was in August. We attended the hearing, got the order granted, and filed the predicate order on the I-360 with USCIS immediately.
Perfect. Okay, Kousha, thanks for joining us, and I want to say thank you to our listeners. I hope you enjoyed and learned from today's episode. Make sure to check out the show notes with the description for access to our website, and also make sure to share this episode with your friends and subscribe wherever you listen to your podcast. We really appreciate hearing feedback from you, so please share a review for this episode or check out our website and ask your questions. We are located in 21031 Ventura Boulevard, suite number 760, Woodland Hills, California 91364. You can also call us at 213-204-6500. Until the next episode, take care and bye.